Any mention? May I please, Your Lordship? Lordship, I beg to mention item number 14 and 15, Your Lordship.
Yes.
I pray for 2 weeks' time, Your Lordship.
No. Here for the private respondent.
For respondent number 4.
In which matter? In 14 or 15?
Me for respondent 5, 6 and 14, Your Lordship.
And in 15 there is no private respondent.
Yes, Your Lordship.
15.
There is, Your Lordship.
So no one has objection. Yes, yes, straightforward. This one we have the petition. And this is matter after 2 weeks. 2 weeks.
Yes, Your Lordship. Similar pray for item number 18, Your Lordship. And for the respondent, Your Lordship.
My lord, nothing survives actually in this case, my lord.
89 for petitioner, my lord.
So what for you are making a mention then if there is
Nothing has survived, my lord, in this case. Because they have come during the winter vacation, my lord. They have filed this application before this honorable court on the ground that the injunction application was not considered by the trial court. Now, my lord, February,
they wanted speedy disposal?
my lord, that's already been
Not
taken.
speedy disposal, my lord. We had prayed for injunction, some kind of interim protection, my lord. Because that time, my lord, at that point of time, the civil court was on vacation, my lord. So we had to move it urgently, my lord, before this honorable court, my lord. And this honorable court had.
But there is a provision for
Well-
moving in vacation, during vacation also in
lord.
argument. Yes. So what happened then thereafter?
So thereafter, my lord, the matter has been listed, but it has not been heard. Then, if I may pray, my lord, in terms of the order passed on 27/12/24, my lord.
So we'll do one thing, we'll just wait, we'll just take up
Well-
the matter. Just wait. Yes.
May it please, Your Lordship.
Yes.
Lordship, I beg to mention item number 23, my lord. My lord, kindly have the matter after 2 weeks.
Yes.
My lord, I'm for the petitioner. I'm for the petitioner here, my lord.
Just on prayer made on behalf of the state respondents. This is matter after
2 weeks, my lord. Deeply obliged.
Obliged, my lord.
I please, Your Lordship. Your Lordship, I beg to mention item number 10, Your Lordship. On behalf of the respondent number 3 and 4.
Yes.
Praying if Your Lordship can have this matter after 2 weeks, Your Lordship.
Objection.
No objection. This also on request made on behalf of so and so. This after 2 weeks. Yes.
Lordship, I beg to make a mention for item 8, Your Lordship. Item 8, Your Lordship.
Yes.
Lordship, I'm praying 2 weeks' time, Your Lordship.
No objection.
This on request made on behalf of the petitioner. Not objected to by the learned counsel for the respondents. This is matter after 2 weeks. Yes.
Obliged, Your Lordship.
I have similar prayer for item 11 on behalf of Ms. R. Dattai, Lordship. Legal aid counsel, Lordship. 2 weeks' time, Your Lordship.
11?
Yeah.
Okay.
LSC in service.
Yes,
matter.
Lordship.
You are there, Mr. Fly. Yes.
Lordship, still is only for one issue, that is that OBC certificate.
Yes. And unions. No objection. No. Same order.
Obliged.
Please, Lordship, I beg to mention item 16. I prayed for 2 weeks' time, my Lordship.
Who is the other side?
Lordship,
No objection.
no objection, Lordship.
Let's same order.
Obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 21, Lordship.
Yes.
Let this matter must come after 2 weeks, Lordship.
My lord, no objection.
It's 21. On request made on behalf of the petitioner. List after 2 weeks.
Highly obliged, Lordship. Your Lordship, I beg to mention item number 17.
Yes.
The conducting council is on sanctioned leave, Your Lordship. Let it come after 3 weeks.
Who is the conducting counsel?
Jai Shilla. No objection, Your Lordship.
You say on the request of the petitioner. List after.
3 weeks.
All right. 3 weeks.
Obliged.
Much obliged, Lordship.
May it please, Your Lordship, I beg to mention item number 5.
I have been prayed for 2 weeks, Your Lordship, as the conducting counsel is on sanction leave.
Who is the conducting counsel?
JM, thank you.
Yes.
I'm on appearing on behalf of Mr. SD.
And Mr. Counsel? Yes.
Your Lordship, I appear.
Yes, Mr. Nagri.
I appear for respondent number 4, Your Lordship.
Yes. Any objection? No. But then he's on leave.
Your Lordship, the
Yes.
matter has been adjourned repeatedly, Your Lordship.
But then what is to be done? Anyway, we'll just. Yes, for how long you want?
2 weeks, Your Lordship.
You just that same thing. 2 weeks. You just say on prayer made answer, not objected to by the land council with the respondents. Just after 2 weeks. Yes, we'll have it after 2 weeks.
Obliged.
Obliged, Your Lordship.
Yeah, please, Lordship, I beg to mention item number 13, Lordship.
Yes.
It is matter take up after 1 week, Lordship.
Criminal appeal.
Yes, Lordship.
It'll be after 2 weeks, then, Your Lordship.
After 2 weeks. Just on the request of the appellant, this is matter after 2 weeks. Yes.
Apply, Your Lordship.
Please, Lordship. Lordship, I beg to mention item 12, Your Lordship.
Item?
Item 12. For the respondent number 4. It's a joint request with the respondent number 1, 2, and 3.
Joint request from number 1, 2, 3.
Yes.
That is not a joint request. That is one-sided request. Joint request is only joint the other side. Yes.
No objection, Lordship.
Just say on the request. Hey, sorry. Say on. Oh, respondents have joined. That is what he said. Just say on request made on with the respondent number 1, sir. List of 2 weeks.
2 weeks, Lordship. Highly appreciated.
Yes.
Supplementary cause list, item number 1.
The issue involved is the jurisdiction of the Lokayukt in relation to the district council. And in this particular case, the petitioner is a private contractor who was allotted a work order for construction of a community hall, and the value of the contract was 9 lakh something. Now, a complaint was filed by the private respondent before the
Private
Lokayukta.
respondent? A private individual. No.
Yes, private individual, and investigation was directed by the Lokayukt, and a charge sheet has been filed and referred to the special court. This issue is seized with this honorable court in 2 matters. Just
Yes, there
supply
are one or two other matters pending.
2 other matters.
Yes.
2 or 3?
Yes.
3, no?
So this is the same
Three
Same
matters. are
issue.
there.
Yes. Okay, then we'll.
No, no.
Oh, you want to say?
Come on.
These 2 matters, and I'm also praying for a stay, of the proceedings, similar to what has been granted in the other matter.
State notice will have to go to the private party, Your Lordship.
The state will be a very relevant party, because the enactment is of the state legislature. Enactment is of the state legislature.
And right now, Mr. Shulai doesn't have any objection to your prayer.
No, but
You have filed a separate
It's a
application
question of
for
law. It's a question of law only, Your Lordship.
for your lordships to interpret.
Yes, just heard Mr. Teleman counsel for the petitioner. Issue notice, returnable in 3 weeks. Along with Ms. R. Colne, appears for the respondent number 1. Petitioner shall take steps for service of notice upon the respondent number 2 within 2 days. Then come to the Miss case. Miss case number 3.
3.
Also,
Yes. Just say heard Mr. Nongri for the applicant. And also heard Mr. Shulam. Learned AG for the respondent number 1.
16.
Yes, sir.
Paragraph. What about the other?
This is an application seeking stay of order dated 29/10/2024 passed by the Meghalaya Lakshya in complaint case number 4 of 2021 and for stay of the subsequent proceeding in special PC case number 3 of 2024 pending before the special judge Tura. Step. Paragraph. Mr. Nongri, learned counsel, contends that the Meghalaya Lakayukta had no jurisdiction over the petitioner, as he is not a public servant. In terms of the definition of section, what is the definition?
2N, my lord.
2N, isn't it?
2N, my lord.
Read with section 14 of the Meghalaya Lakayukta Act 2014. He submits that entire initiation of the criminal proceeding of the against the petitioner is without jurisdiction and is liable to be stayed. Step. Mr. Kandishulai, learned JG, prays for grant of some time to take instruction and at this stage does not dispute the contention raised on by the applicant. Give a paragraph. Just say in view of the above, the proceeding of. See, is there any purpose of staying the order of Lokayukta? We'll stay the proceeding.
Yes, my lord.
The further the proceeding, further proceeding of the special PC case number 3 of 2024, pending before the special judge Tura, shall remain suspended till the returnable date. Let us see other side.
Yes.
Then list after 3 weeks.
Apply.
Please take steps. Even in the miscase also you take steps.
Yes, my lord. I'll do that. Detail.
Daily cause list, item number 1.
My lord, this relates to the CMJ University.
Yes.
In the last occasion, Lordship gave me time to take instruction as to whether we need to file a implementing application. But I've seen the case, my lord. the government, since university has been dissolved, government has appointed one of the Joint Secretary of Education to oversee the dissolution process only. So it is still in the hand of the respondent state. So it is not required to implement that particular officer. Now, in view of the one issue Lordship has raised earlier occasion, whether dissolved university need to be remain as a party here. My lord, this issue, once the university is dissolved, the legal entity of that university stands vanished, and the university doesn't have legal capacity to represent here as a party. So in view of that position, my lordship may strike out the name of the university and proceed on merits, my lord. I'm ready to satisfy that.
No application is needed to file for that.
My lord, lordship, it is a dissolved university. Undisputed
application
one.
be filed, Your Lordship. Let them file an application. Then the matter be heard, Your
Why do you
Lordship.
have
And done.
confusion for a small thing? Of course, maybe we can act on this, but then you file one small.
Dissolved university is in public domain.
That
It
is
is a state order.
That is a matter of argument, Your Lordship.
It is a state matter. State matter.
See, when it comes to
Because under the Act, Your Lordship, there is no such liability, Your Lordship. After the
That one I will satisfy.
anyway, just
I'll
file an
satisfy that
application
one.
for striking of the name of these things. Okay. Just say, Mr.
My lord, here that will take some time. With the students, those students earlier,
This
they
application can be signed by one of the many students. I think I don't think like you have to obtain signature of everyone, isn't it?
But that is true. That is true. But since I'm submitting as officer of the court, and dissolution is passed by the government, and
Lordship, I have
upheld by the
objection
Supreme
to
Court.
that, Your Lordship. For
So there is
striking
no
of
question
Your
of
Lordship.
any complication in future.
For striking of this university, Your Lordship, I have an objection. Let them file an application. Let the matter be heard on that.
See, if it is objected, then you need to file an application. Anyway, let us see. I just see. Mr. Ajil Sangdesh, Learned Senior Counsel appearing for the petitioner, submits the that since the CMJ University has already been dissolved. The respondent number
5 to, it will be 5 to 10.
Maybe struck up from the area of
Remaining as state response.
area of parties, as these positions are no more in existence. Just let the petitioner file a formal application
Lordship. Highly apply, Your Lordship.
for same order anyway. Just a minute, just let us finish the order. Let the petitioner file a formal application seeking striking of the respondents number so and so. Just say from 5 to 10. When shall we list? When shall we
After 2 weeks.
list after 2 weeks? Now in the other matter also same order, it will be instead of Mr. Senior Counsel, you just say Sandesh to Mr. Sandesh.
Apply, Your Lordship.
Item number 6.
But here we are actually to file some written argument.
Well, I'm submitting, I have prepared already.
What is that matter? This matter
This
about?
is regarding school teacher. My lord.
School. Yes.
Well, I'm submitting my paper. You submit first.
You intend to submit? But then you have not orally addressed the court, is it?
My lord, more or less the argument is over. My lord.
Your oral argument is also over.
Yes, my lord.
Is it a fact, Mr. Sandesh?
My lordship has heard the matter. Allow us to file a written submission.
So have you?
My lord, I am praying for a week's time. My lord.
Okay. Just say written gist of just say a gist of argument.
You have filed. You are not filing.
You are for?
She's for the private school.
You will also file written.
She's also for the managing committee.
You will also file. You also desire to file. Okay. Okay. Just a sec. Just a written gist of argument has been filed on behalf of the writ petitioner. Stop. Mr. K.P. Bhattacharya, Learned Counsel, appearing for the respondent number.
One of the state respondents, my lord.
Number so and so and MS appearing for the respondent number 5 and 7. Pray for grant of some time to enable them to file their written argument. Stop. Prayer allowed. List after.
My lord, I am framed for a week's time.
After 1 week. You may have to refresh again. Let it be filed and just refresh the code. The code must.
Obliged, my lord, in fact, item 6 and 7. Both.
All are same.
Yes. My lord.
Same order.
Same petitioner, my lord.
So same order.
Yes, heard together.
They are also you filed separate or
It is a common.
It's a common.
Oh, it's a common. Lordship has
Same
not common.
Yes.
Item number 9.
Yes. Yes, Mr.
My lord, this matter was heard at length, my lord. On the last occasion, my lord had instructed the parties as to what are the provisions for exit visa. What is the
Provisions for?
exit visa? In case, yes. Ma'am. So I made inquiries, my lord. If a foreigner is staying within the territory of India, my lord, and the visa expires, then in that case, my lord, he has to apply for exit visa from the FRO Shillong, from the state. And there is a particular, it is online, my lord. It is online. That is the mode, my lord. And they grants in such cases, they grant some limited time for exiting the country, my lord. So that is the thing. But for that purpose, again, the parties has to submit their passport and other documents, my lord.
Here we are dealing with conviction, isn't it?
Conviction, my lord. Initially, my lord, he was framed under section 468 and 471, read with section 14 of the Foreigners Act, my lord. The learned trial court acquitted the petitioner herein, my lord, from the mischief of section 468 and 471, my lord. But surprisingly, my lord, the petitioner was convicted under section 14, my lord. But apparently, my lord, at that point of time when the petitioner was arrested, my lord, the visa had not expired, my lord. Had not expired. But the reason behind, my lord, why he was convicted under section 14 was that, my lord, that on the last extension of the visa, my lord, surprisingly, the extension was given only for 1 day, my lord. So that raised some suspiciousness before the trial court. So in view thereof, my lord, he was convicted and to undergo imprisonment of 1 month and a fine of rupees 5,000, my lord. So therefore, my lord,
imprisonment for
1 month.
1 month.
So thereafter, my lord, appeal was preferred, my lord. But however, the same thing was upheld, my lord. So we are before your lordship.
This is a revision.
Revision, my lord.
So you have coming is concurrent finding.
My lord, that is true. Concurrent finding.
And what is the main ground of challenge?
Main ground of challenge is that, my lord.
So far as the judgment is judgment of the trial court and the appellate court is concerned.
My lord. Admittedly, my lord, on the face of the record, my lord, when I was arrested, in fact, I had, as per the requirement of law, my lord, after arrival in Shillong, I had reported before the FRO Shillong, my lord. As per law, I have to report. So when I produced my passport along with the visa, they found some discrepancies in the stamp therein, my lord. So thereafter, my lord, the FRO Shillong, my lord, had communicated with the FRO daily to confirm whether this extension was given to him or not, my lord. And fax message was received, my lord, from the FRO daily, saying that it was never extended. Now, my lord, my argument before the learned trial court was that, my lord, the authority, that is the FRO Delhi, was never examined. Never examined. That apart,
Have you given any notes on your argument? No.
I have submitted my written argument also.
In this matter? There appears to be a typed copy of deposition here, but then is there any written argument? Okay. It must be there.
It is dated 20th 7 2023.
Yes, 21.
My lord.
21/7.
My lord. So, my lord, nor my lord, the original seal, a rubber seal, my lord, which was alleged to have been forged, my lord, that was never seized and was never, my lord, forwarded to the official, my lord, for comparing, for the purpose of comparing, my lord. So, in absence of the original...
Now, see, 468, 471 is goes. The court did not find any charging.
My lord.
Now, what about the charge or offence under which you are found?
14, my lord, for overstaying within the territory of India. But what is the question of overstaying, my lord? At the point of time when I was arrested, my lord, my visa, my lord, was valid, my lord. It had not expired. And when forgery is not proved against me, my
At the time
lord.
of your arrest, your visa was valid.
My lord, yes.
Is it? Is it
Yes.
correct, Mr. What was
his visa expired, but he did not renew it, Lordship, and he has been convicted under Section 14.
Means
for
legally, what
overstaying.
was the stand? What he says that his visa was valid. That means just keeping apart that part, the extension part, which you say outcome of forgery. Keep apart that thing. As on the day of his arrest, whether he was admittedly, whether his visa was valid.
No, it was not valid, Lordship. Lordship, he was arrested. He was.
go through properly.
Yes. This matter, Lordship, I have to refresh my memory, Lordship. It has been repeatedly adjourned again and again.
Okay, so you have given a written notes of
No,
your
it's ready, Lordship.
This matter was heard by this court also, many.
Yes.
Now, if a person is not found responsible for forgery and cheating,
Yes.
now assuming what Mr. Gurung says that his visa was otherwise valid on the day of arrest, let us say he is incorrect. Let us say he was not valid also. But then if he himself becomes a victim of forgery, why should you punish him? You are not holding him guilty. That means he himself is not responsible for the wrong.
The wrong, forgery.
So he himself become victim of the wrong. So in such a case, why should he be held guilty? I do not know. That is one thing. Will you please refresh?
Yes,
You
Lordship.
refresh and we'll come back.
My written argument also is ready. Almost ready.
But then
I'll
we'll
file
not have
it.
it next week. We'll have it after 2 weeks.
Yes,
Next
yes.
week,
2 weeks.
there will be a bit problem with our official.
Yes.
So, and please, chronological. See, like a concurrent finding of fact is very difficult to receive. Until and unless you show that something patently illegal or something you see, is not borne by record. So that is what the problem is. The High Court's thing also will be very limited to go and to they alter the finding of facts. Now there you have to see, and please see in that line that even assuming also, say supposing if you are not held guilty of the principal offence, then whether you can be punished. And where are you now?
I'm in Shillong, my lord.
Under your bail, on bail.
My lord, I am.
The visa expired, Lordship, but it was not renewed. It was as per the
So as on the
endorsement.
day of his arrest, according to you, his stay was not valid.
Yes.
in view of the
Visa,
fact
it
that
was
there was
not
an
illegal.
allegation, it was forced.
No, that
Now,
is-
if
that
it is
second
forced,
part. But then you say that his stay was valid on the day of.
yes,
It could not have been.
mine.
I do not know. How can you be arrested if your stay was valid as on the day of the
Exactly, man. But that, presuming that it was forced, that's why I was arrested, man.
The extension also, Lordship, it was given just
No,
one
but
day
then-
prior to the expiry of the.
But then the finding of the trial
extension.
court is
Yes.
that it is forged, but then you have not done.
I'm not responsible.
Not,
So he himself becomes a victim.
he did not report to the FRO office
He
for
did not
registration.
know how he would know it is forged. Maybe he is availed service of some agent.
Agent,
The agent
yes.
has given him,
Yes.
and he was not aware that it is forged. Till you say that it is forged.
When he
Now initially
reported,
you brought a charge against him, saying that since you have produced it and you are staying on the basis of this,
Yes.
you are responsible for forgery. Now you find that he is not responsible for forgery. Then how come he himself becomes an accused then? He himself becomes a victim then?
yeah. The case is like this. He's reported in the FRO office
If
law
somebody is,
and those
does not have guilty
discrepancies.
intention, then why should he be? Why should he be this thing? Just see.
You will see, Lord.
Just see.
Yes.
And, Mr. Gurung, you also see. Like
My
our
lord.
scope is very, very limited. Which way?
Yes, Lord. We'll see.
Just on the request.
I'll file my written argument also.
You do not make it lengthy. Just head notes
Yes,
if you
yes,
want to
Lord.
give. Otherwise, it causes a problem for court to go through his. Court doesn't want that. But then yes, so if you give only the bullet points, that
Yes,
helps. That helps. Of course. Because sometimes while noting we miss something. We miss.
Yes, Lord.
Okay, just on the request made on behalf. Oh, maybe doing my mistake, pardon me. Non-net additional PP on behalf of the state. Appearing on behalf of the state. And this is a matter after 2 weeks to enable him
Highly obliged.
to submit a written gist of argument.
Obliged.
18.
Yes. Yes, Mr. Karim, you were trying to.
Well, look, they have this civil revision was filed during the vacation bench, my lord. What had happened is that the suit is pending before the trial court. So they have filed some application with regard to injunction. That was not heard. Then they had approached this honorable court. This honorable court had passed some order because of the vacation, my lord. Now the trial court has already opened in the month of February, my lord. So whatever the grievances they have, they can agitate it before the trial court, my lord.
Okay.
That's the only case, my lord.
You have challenged some order. Order did in
Well, here,
1912.
well, what
What
had
is
happened?
it, 1912?
Well, here what had happened. It's at page 46, my lord. First, if I may take my lord to page 40.
Page?
Page 40, my lord. Page 40, I'll take you, my lord, to page 42, paragraph 4, my lord. Page 40 is the order passed by this honorable court, my lord. If I may read the order, my lord. My lord, here what happened. Initially, we had filed a writ petition, my lord, due to ensuing vacation, my lord. There's 2-3 days left for vacation, my lord. We had filed a writ petition for, my lord, illegal constructions being carried out by the respondents, my lord, in the suit property, while the partition suit was pending before the trial court, my lord. So, my lord,
But then why a writ petition for?
my lord, here what happened, there was some urgency, my lord.
But then emergency, there is provision for civil court to take up the vacation, during vacation. Why by writ petition?
My lord.
There is a provision in law
Yes, my lord.
that in case of emergency,
My lord.
during vacation, civil court will take up.
But those proceedings, my lord, would take time. For seeking urgent relief, my lord.
How come it takes time? Urgent.
I'll take my lord to the order passed by the
delay
trial court.
proceeding will take time. Can it be a ground for filing writ petition? Anyway, what happened to your
Yes,
writ
madam.
petition? We do not know which way things are.
Yes, my lord.
You want to say that since there was a civil court's vacation, you
My
could
lord.
not file it, these things. No, there
No,
is a
not-
provision.
no, not we
See
don't
the
file.
former, the High Court, civil court's rule by High Court. It is there.
I'll peruse it, my lord. I'll peruse it.
Anyway, then what happened? What order was passed?
If I may read para 4, my lord.
Yes.
I've heard counsel for the parties and also examined the materials and as placed by the land counsel for the petitioner. The writ petitioner has annexed at Annexure 3 to the writ petition a copy of the plaint title suit number so and so, which is a suit for partition and declaration of right in interest, and has submitted that it is at the stage of issuing documents. It is also noted that respondent number 1 in the instant writ petition is also added as pro forma respondent number 6 in the said title suit. This being the situation, coupled with the fact that no materials have been brought on record to show that there is constructions going on in the suit length, and also due to availability of alternate remedy, the writ petition is not entertained at present. The writ petitioner is, however, is at liberty to approach the civil court where the suit is pending, and a concession is given that on such application being preferred before the trial court, the same shall be taken up and orders passed thereon expressly. So, pursuant thereto, my lord, we had filed an application before the trial court, enclosing the photographs.
So there is nothing special in this direction,
my lord.
That is, the court has said whatever is provided in the law, you should do that, isn't it? Yes. Then.
So thereafter, my lord, enclosing the photographs, and my lord, we had filed an application before the trial court under my lord, section 94, my lord. If my lord come to page 46.
Yes.
Yes, my lord. Page 46. May I read, my lord?
Yes.
Seen miscase number 134T of 2024, filed by the petitioner under section 94, read with section 151 CPC for grant of ad interim maintenance. Now it's maintenance. Counsel S. So-and-so is present and submits that he could not find the opposite parties, hence he could not serve the notice. Counsel submits that the same of Milliam has passed the order for partition randomly partition the suit. Partition the suit among 4 brothers, White, order dated 21st August 2024, and the opposite party has started constructions. Counsel further submitted that defendant number 3 and 4 had objected to it and that no notice was sent to the petitioner. Seen order dated 21/8/2024, marked as Annexure 3, counsel submits that opposite party recently started construction. Counsel prays respondent be restrained from carrying out constructions. Heard counsel, it has come to the notice of the court that the matter for partition suit number so-and-so is pending before this court, so also miscase number so-and-so, under so-and-so. Seen the counsel for defendant number 3 and 4 and 2 are appearing before the court for said matters. On perusal of the matter on record, this court deems it fit and proper to hear all the parties before any effective orders be passed. Petition to issue notice to all the opposite parties, fix so-and-so for SR and SC,
Yes.
my lord. So thereafter, my lord, what happened? We had preferred a revision before Honorable Court, my lord. This revision petition, my lord. This instant revision petition, my lord.
How come a revision comes against the order passed in an injunction matter?
My lord, here,
Section 94.
immediately after that, my lord, this was vacation, my lord. We had preferred this application in the vacation mention, my lord. Civil code was on vacation, my lord. So thereafter, we have preferred this revision petition before this Honorable Court, my lord. Then this Honorable Court, my lord.
Court, you filed a suit, you filed an application
Yes, my
for
lord.
interim.
Yes, my lord.
Then over and over, you filed an application under Section 94.
Yes, under my lord, this Honorable Court, my lord, in a writ petition, had directed to file the application before the trial court, my lord.
The direction which you read out, just.
Yes, my lord. First order which I read.
Court did not say that you should. It said liberty approves the.
Yes, civil court,
So it did not say that if I come up with an application.
But liberty, my lord.
Liberty to approach means what?
Liberty
you go
to
and tell the court that, see, my application is pending, you take up this. That is also.
Yes, my lord.
You see, you basically you misinterpret an order and you give rise to all those multiple litigations.
No, my lord.
Make the things unnecessarily complicated. Anyway, then what happened?
So, my lord, here is at liberty to approach the civil court, my lord, because there was 2-3 days in hand. For that reason, my lord.
No, that period has gone now. What remains now?
So thereafter, my lord, we had preferred this application. After this application, we had preferred the revision petition in the vacation bench, my lord. May I just take, my lord, to the order passed by this.
What is your prayer before this court now, right now?
Let me first take my lord to the order passed by this honorable court.
Yes.
It's order dated 27/12/24, my lord.
In this matter?
Yes, my lord.
Just a minute. Order dated 27.
27/12/24, my lord.
Yes.
May I read from para 5, my lord?
So it's a long one.
Para 6, my lord. I'll start from para 6,
Yes.
my lord. In the backdrop of these facts and circumstances, the learned counsel has submitted that this court may be pleased to direct the respondent number 2 to refrain from carrying out any construction work in the said premises till the said application pending before the trial court, being Miss case number so and so, is disposed of.
That is your application under 13 and Rule 1 and 2.
Yes, no, my lord. 94, my lord. 94. This court, on considerations of the submissions made at the first instance, directs the petitioner to take steps for issuance of notice upon the response, the same returnable within 2 weeks. Again, on considerations of the submissions made as regards the ongoing constructions carried on by the respondent number 2 within the suit length, in the interim, it is hereby directed that no further constructions work is to be carried out till disposal of the Miss case number 134T 2024, my lord. 24, my lord. This is also passed by this
So what happened to this 134T?
This application is still pending, my lord. The next date is
So that is okay. Then get it disposed of. We'll direct the court to dispose it of. Finish.
July. 15th July, my lord. The date is 15th July.
Get it disposed of. So what is the causes remains? Court has protected you till the disposal of that 134 application.
On these
You get it
lines,
disposal.
my lord, my lord may.
There remains no cause for you. That is basically for him. He is aggrieved now.
Who, my lord?
You are no more aggrieved now after passing of this order.
My lord,
This is he himself now. This is the other side who is aggrieved. Because this interim order is in your favor.
My lord,
This interim order would continue till your application is disposed of.
Yes, my lord.
So what
on these
remains
lines
here?
may be disposed of.
So that is what.
Yeah.
You have got a very good order at the very first instance.
My lord.
And basically, yes. Right, Mr. S.
But the kind of illegality, my lord, carried out in the suit premises. The kind of illegality was carried out in the suit premises, my lord, during the pendency of the proceedings, my lord. They were carrying out constructions, my lord, disconnecting electricity, my lord.
That will be a different thing. If you say violation of the violation of the interim order, you should have taken their procedure.
It was taking time. That's why we were compelled, my lord.
That you take steps appropriately.
We'll do it, my lord.
In one petition, you cannot get all kind of relief, isn't it?
But the situation as such, my lord, we were compelled, my lord. Otherwise,
Getting all kind of relief in one petition,
it is understood, my lord.
is difficult.
It is
not good for lawyers.
It is understood, my lord. Understood.
Well, just say. But then, I do not know what is your prayer in the revision application?
It's for quashing of the order, my lord.
That order, my lord.
19th, page
Page
46, my lord. Quashing of the order dated 1912, page 46.
Prayer is at page 11, my lord.
My lord.
And what is the prayer? Prayer is
Prayer is at page 11, my lord.
Okay. Just say hard so and so, not everybody got this. Then you say by this revision application, the petitioner has challenged the order dated 19/12/2024, passed in Miss case number 134 within bracket T of 2024, arising out of title suit number 23 within bracket T 2022. Pending in the court of. What is a learned trial court? What is meant by this learned trial court? What court is this?
It's ADC, my lord. Assistant Deputy Commissioner, my lord.
No, pending in the court of the assistant to deputy commissioner. Within bracket, you write judicial. Shillong. Now even this order is quashed. If you quash it also, what would be the consequence? Okay. You wanted this court to take over the injunction matter and pass some interim order.
Yes, my lord. Yes, my lord.
But as far as submit, my lord, and for the respondent number 2, his only prayer is as regard to the order dated 19/12/2024.
Yes.
Because injunction was not granted. Now, my lord, as far as the order which has been passed by this court, my lord,
Yes.
dated
27/12/2024. Yes.
so as long as this order will remain, my lord, this will create difficulty for the other respondents, my lord, because my
Other
lord, as far as
This will not remain if you once you get that 134 disposal. And
decide his applications, my lord, we have no issue. As long as this order is
that is what this court will dispose of the matter. Saying that since it is pending for disposal, so parties will go and get the same thing disposed. Nothing else.
My lord, our grievances is only against respondent number 2, my lord. Other respondents, my lord, they are supporting our case. Other respondents, my lord, they are not interfering. Only number 2.
You are
Only number 2, my lord.
So Mr. Kheriam is supporting you.
My lord, here
We are yet to file anything.
CF Milam, what they have done is, my lord, they have muted the property, my lord, without seeking NOC from the other legal heirs.
Wait.
Yes, my lord, it is
if
true.
you all talk together, then this court will not.
Yes, my lord.
You see, you said that only the respondent number 2 is the
Yes,
contesting respondent.
my lord.
The Mr. Kheriam is not contesting.
My lord, here before the trial court, my lord, we have made the respondent number 6 as the performer respondent, my lord. Performer, my lord.
now, my lord, as far as mutation is concerned, it has already been done. Even in their name also, patta has been issued. If I can bring all that in record, my lord, that will be.
See, revision, we have very limited jurisdiction. See, question here is that they have come, approached this court because their prayer for injunction was not granted, and that is how.
Right. So, my lord may dispose this.
And since this order 27/12/2000 basically virtually has finally disposed of the matter. Once it said that this further construction work to be carried out till the disposal of the so and so 34, that amounts to disposal of this matter. Thereafter, pendency of this matter is totally useless.
Now, my lord, that amounts to granting the injunction by this court, my lord.
Yes, but then it is conditional upon see.
So let the trial court pass appropriate
So
order.
that is what has been provided therein also, and you have not come forward to get this order vacated. So it has remained for so long, and now once this 134 is finally fixed for disposal, what is the question of disturbing with it? You should have made your objection to this order at the very initial stage. You did not do it.
We have recently entered a
Actually, see, after this 27 order dated 27/12/2024, nothing remains in this revision. See, nothing remained.
Yes, my lord.
So that is what.
My lord, even I have been engaged very recently in this case.
No, we can understand.
My lord, only my prayer is, my lord, if this order, my lord, 27/10/2000, this order remains, my lord, there will be nothing for adjudication for that this case.
No, that is not.
So my only prayer,
See,
my lord,
it has been made specifically
Yes,
here. It is hereby directed that no further construction are to be carried on till disposal of the said case number so and so. So you get a disposal. See, this order, you should have challenged it at the very initial stage. Now you have not done
we have entered
it.
very
So once, why to disturb it at this stage? Well, just say. Okay, pending before this one. So what we said? Pending the course.
Yeah, and also, my lord, whether this civil revision is maintainable, that is also one question, my lord.
What? Exactly, Mr. Then you should have challenged it at the very first instance. Why you are doing it now? Now, what purpose it will serve? We can understand. You may have valid points, okay. But then what's the purpose now? We'll remand it back. And whatever order is passed in that 134, you will have, and probably we do not know. That is for you to decide. Of course, this court may not go into all those things. But then the fact remains that there is a suit There's an application under Order 39 Rule 1 and 2, and there is application under Section 94. Now, which is to be, what is to be dealt with, that is for you to see, you to find out. Nothing more is required to be indicated, is it?
Let it be.
So allow him to live in peace for some time.
And in fact, the property was already mutated in his name also.
That is okay. That is on merits. That is on merits. We'll just say. It's all right, Mr. Singh. Just allow the court to this thing. Then you say, it appears that at the stage of the admission of this revision application, this court, by order dated 27/12/2024, has passed a direction restraining further construction work by the reservoir number 2 within the suit land till the disposal of the miscase number 134T 2024. When is your case is coming is?
15/7 July. 15/7, my lord. 15 July.
Yes. It is submitted by the learned counsel, appearing to the parties, that the miscase number 134T 2024 is coming up on 15
July, my lord.
7/2024, before the
25.
for final disposal. Stop. Just you say, in view of the above, there remains nothing more to be decided in this revision application. The parties may approach the trial court seeking redressal of their respective grievances. Anything more needed? No.
That's it.
With the above, the revision application stands disposed of.
My lord, if
You are very lucky. You have got many good orders.
Lucky, my lord. Here, my lord. Of course, I've been protected by this honorable court, my lord. Of course, I've been protected by this honorable court, my lord.
Overprotected.
My lord, there, my lord.
Okay. We'll do one thing. It is made clear that the learned trial court shall dispose of the miscase number 134 so and so at the earliest, and no unnecessary adjournment be granted to the parties.
Then
you say with the yes.
19.
In that matter, my lord, the learned.
Yeah, I have the
senior-
report, Your
The
Lordship.
report.
I have
Yes,
the
ma'am.
report.
Then next date can be taken up. That's
I
young
have the
rise,
report.
GK young rise matter.
I have the
that's-
report.
Case quashing of FIR.
Yes, my lord.
Yes. This also will come after.
After 10 days.
10 days or
time.
2 weeks.
Yes, it should not be in the next week. After this
After.
2 weeks. No, after 2 weeks. It will be
Right.
schedule also will have to see.
My lord.
Apply, Your Lordship.
Just but request made with the parties list after 2 weeks. Yes.
All right.
There is other case also. Okay.
Apply.
Yes, you intended to take up any matter? Yes.
Yes, item 22 is there for hearing, then
all right.
let it come after 2 weeks. Something that next week it's okay, but if your lordship
Next
is
week means the problem is that still we will be having shortage of one steno. So if we hear also anything, that may not be for any purpose if we cannot pass any order.
so let it be after 2 weeks then.
Lordship, before we proceed with the hearing, the petition is defective, Lordship.
What for?
Lordship,
Just give us the file. Just. Right. Yes, what for it is defective?
Lordship, I draw Lordship attentions to para number 2, Lordship,
Of the petition.
of the petition.
Yes.
Para number 2, respondent number 1 is the mother of respondent number 2. Lordship, respondent number 1 is the state of Meghalaya.
Achha. Anyway, just there appears to be some clerical. You just correct those clerical errors before this is
Lordship,
taken
yes.
up.
Subsequently, there para 8, para 11, para 12. Not only with this.
Yes,
character.
madam, just you take your
Okay, we'll
thing
correct.
to take charge of these things. Let him go through the petition and make all those corrections.
Let it come after 2 weeks. We'll
Yes,
make the
ma'am.
necessary correction.
Okay, just wait for the learned senior counsel appearing for the respondents. This is matter after 2 weeks. Yes, it is pointed out by the learned counsel appearing. You are appearing for which respondents?
2 and 3, Lordship.
Respondent number 2 and 2, that there are several clerical error in the petition.
Lordship, I'm appearing for former respondent.
It's all right. Okay, just record the appearance. Just there are pieces also. The petitioner shall verify. Petitioner shall verify and check the petition and correct the clerical error.
We'll correct in that petition itself, which is on
Yeah,
record.
you will do it, but then you will do it by in a night way. See, just say that. Just say. Before that, say you just say the. Do not give the last thing. You just say the petitioner is permitted to correct the clerical error
Lordship, if I may interject, my lord,
appearing
with your
on
lordship
the.
permission.
Just a
If I-
minute. Appearing in the petition. Yes.
If I may be allowed to interject, my lord. My lord, even the cost title, my lord, is defective.
Is it? If that be the thing, then we will definitely not allow you to do
Defective in
something.
what manner?
Then we will withdraw this petition and then.
Where is the cost title defective?
What is the which part of Mr. Ranger?
Page number 3, my lord, of the petition.
Yes.
State of Meghalaya, represented by Secretary, Government of Meghalaya.
Yes.
Then?
Secretary Government of Meghalaya. Not the Chief Secretary of Government of Meghalaya. Now Secretary, how many secretaries Government of Meghalaya?
Different departments and.
You see, this sheer negligence on your part, madam, your team probably did not check it properly. Now it should be through which secretary should be. Even for them, if they have to take instruction, from whom they will take instruction? Just tell us. Madam, you withdraw this petition, file afresh.
Well, that is also a minor correction only, that will do that minor correction. Only Chief Secretary.
Then
to
how
be-
this entire petition will be, you see, marked by corrections and corrections?
Only respondent numbers needs to be changed, that's all, you know.
It's difficult. Already,
or will
it has been pointed out that there are several mistakes on many paragraphs, starting from paragraph 2.
Paragraph 2, paragraph 8. Paragraph 11, paragraph 12.
Well, only the respondent number is to be added. There is not in the pleadings. Only the number, respondent number needs to be changed.
Then,
So there is no
if-
major changes, my lord. only the respondent number 1. In place of respondent number 1, it should be respondent number 2. Only those figures needs to be changed.
It's okay,
That's
but
it.
then so far as the
It's
court's
not
record,
major correction.
see, court record is concerned, it doesn't look nice that there are many corrections.
Or we can,
Normally-
in the
normally-
court, my lord, we may be permitted to give a corrected copy. In so after making the corrected copy of the petition, we can place on record. Corrected copy of the petition will be placed.
Again, you have to file a corrected copy of the petition that has to come with the annexures, then it will be again with the same thing.
The entire
Will be
document with
problem.
annexures, entire document, a corrected copy also we will place on record, my lord. Because others, in these three paras, only the numbers, respondent number is to be corrected.
Just do one thing. Just cancel this entire order. Just, you see, like it has been pointed by the learned counsel appearing with the respondents that this criminal petition is marked by several critical errors. Stop. The petitioner shall file a fresh set.
Corrected copy, my lord.
Now again it has to be, see, this is already has come as a court record, no? That is the problem. Then what do you do? Do we ignore this?
No. Along with that, a corrected copy will be there, my lord, that can be referred to. Corrected copy is brought on record.
Just the petitioner is permitted to file a corrected copy of the criminal petition along with annexure thereto, and supply
And we
the
also
copy
supply
of the same
corrected copy to the parties.
to the counsel appearing for the respondents. Stop.
Obliged.
As prayed for, this matter after 2 weeks. As prayed for by the learned senior counsel for the petitioner, this matter after 2 weeks. Yes. No other matter.